So in this 1-hour webinar, we're going to look at 5 key topics to do with construction contract payment. Preceding that, there'll be a short welcome and some information about who we are and what we do. But into the meat of the webinar, we're going to be looking at the philosophy and context of the Housing Grants, Construction and Regeneration Act. Then we'll look at the Act and the scheme themselves, which one is going to apply and when. Thirdly, we'll tackle the common mistakes and pitfalls and have a look at the independent certifier's role. Fourthly, we will hone in on a recent piece of case law. A look at a case called JSM against Western Power. And finally, to complete this webinar, I will give you a summary of key takeaways that then you can apply into your job, talk to your colleagues and clients about, and make progress in your contracts. Let's flip it round now and look at the perspective of the payor. So a big thumbs down to mistakes and pitfalls from the payor. We've got 4 in this case, as opposed to 2 on the prior slide. That's because we've got these 2 notices. So if there's no payment notice, then the payor doesn't put in the payment notice saying, this is how much we're going to pay you. Thank you very much for your application for payment. Well, if that notice isn't done, that's a statutory notice. Then section 110B says that the payee can also serve a payment notice and or the sum which is in the application for payment will be the sum which is the sum due. So the payor's lost that opportunity first off. There is a second bite to the cherry though. If a pay less notice is given, and there's an if because it's not an obligatory notice, but if it is not given and should have been given, then the payor will pay the sum in the payment notice or in the interim application for payment if there hasn't been the payment notice as well. So we're always looking back towards the application for payment. Again, the payor's lost an opportunity.